Good day, my name is Albert Mouton. I'm a legal advisor with the SEESA Labour Department.
Good day, my name is JG Plessis. I'm a legal advisor at SEESA Labour in Pretoria.
Good day, JG. Very interesting topic today, consisting of two components. Firstly, if you catch your director involved with any form of transgression, can you take action? If so, how? And secondly, can you not simply rely on an automatic termination clause as agreed upon in a contract? Now, I'd like to pose this question to you just for a bit more detail. Let's say, for example, you catch a director with a hand in the till, fraudulent behavior. Are you supposed to treat him or her as you would any other employee? Is a director deemed an employee? And if so, can we not simply rely on an automatic termination clause? If they both consented and agreed to this clause, and let's say, for example, it says if you are found to be stealing from the company, your employment automatically ends. Can we not rely on such a clause?
Albert, I think in this regard, the first important step to take is, as you said, to determine whether this director will be an employee or not. And for that, we will turn to the definition of an employee as set out in the Labour Relations Act. Now, Section 213 states that an employee is any person who works for another person or the state and receives or is entitled to receive remuneration. But that's only one part of the definition. There's a second part of the definition that brings out a very big gray area. And it states that, and any other person that assists in carrying on or conducting the business of the employer. Now we can clearly see that this is now a bit more difficult to determine whether a person is an employee or not. And if we look at the director, in some cases, directors don't receive any remuneration. They receive a director's emolument, they receive a shareholder share, or they don't receive anything, but they assist in carrying on the business of the company. They do work at the company itself. And if we then look at that definition, in some cases, a director will be regarded as an employee. And if he's regarded as an employee, he is entitled to the rights as set out in our labor laws.
Okay, wow, that's a very wide net, very broad definition. So there's always a risk there without even knowing it. He might or she might be entitled to all the laws ordinarily given to normal employees. Now, if that's the case, in terms of the actual process of carrying out disciplinary action, is that too also the same as you would follow a process for any normal employee?
Yes, we again look at the Labour Relations Act. Schedule 8 of the Code of Good Practice in the Labour Relations Act deals with dismissals. And it very clearly states that if you wish to terminate the services of an employee, you have to follow fair process. Secondly, there's a rule in our law which is called the audi alteram partem rule. This rule means both sides of the matter must be heard. So if we look at Schedule 8 and we look at this rule, it means that if you wish to terminate the services of an employee, then you must first hold a disciplinary hearing. That's the formal process. And secondly, you must give that employee an opportunity to come and state his case, to challenge your case, challenge your witnesses, and challenge your evidence. And only once this has been done can you legally terminate the services of that employee.
Okay, wow. So on the face of it, in essence, you can't then rely on any automatic termination clause because you have your right to face your accuser, if I can put it in that way. And I know there's a lot of confusion on this topic because in the past, these clauses were often accepted by CCMA and courts. Even as recently as 2009, in the case of Sandane versus Prestige Cleaning Services, I see that actually the Labour Court did say that if you agree to a certain event happening in the future and you agree that can end the employment relationship, then that's a valid contract or valid clause in the contract. However, I also know since then the CCMA and courts are not so willing to accept these clauses. Just a year after that case I mentioned, in 2010, there was another case, the SA Post Office versus Mampule case, which actually went all the way to the Labour Appeal Courts. Now, just for a bit of context, in this case, Mr. Mampule was actually put on the board of directors as a director and also hired or employed as a CEO, emphasis on the word employed. The contract signed by all parties relevant to the contract stated that should the individual ever be removed from the board of directors, in turn, automatically, the status of CEO would also come to an end. In essence, the job would be taken away. And the question here was, like so many cases before that, is it legally valid? Is it legally enforceable? And in this particular case, the court said, no, it's not. It's actually a process of circumventing the Schedule 8 disciplinary process. And it's contrary to the right not to be automatically or unfairly dismissed. So we must be very hesitant nowadays. Although they were once very popular, more so nowadays they are being rejected.
Well, then, Albert, it's clear that ending your employment does not automatically end your directorship, and vice versa. Your directorship being terminated does not automatically end your employment. That means, I'm guessing, two processes, and I've obviously discussed now the labor side, but is there another process in terms of the directorship that must be followed?
Absolutely. Now that goes to the Company Law Act. There's a specific process in terms of Section 71, where shareholders who've lost confidence in a director, they're well within their right to bring, if I can put it this way, allegations or charges against the individual. But even in that scenario, the accused or the director in question has a right to give their side of the story, has a right to challenge whatever's being brought forth to them. So in both the Labor Relations Act and the Company Law Act, there's always the principle of facing your accuser.
Okay. Well, then it's clear the director wears two hats. He wears his employee hat, he wears his director hat, and there's the two processes that must be followed. But now my question to you in this regard is, we've seen this gray area in the definition of an employee. What would your advice be to an employer if they want to terminate the services of a director, but they are unsure of whether that director is an employee or not? What would your advice be in that regard?
In these cases, err on the side of caution. It's always safer in the proceedings internally to deal with both the labor side and the company law side. Don't just assume the person is not an employee as director. Rather consult with SEESA, get our advice, and when in doubt as to whether the person is in fact an employee, I would still recommend following the internal disciplinary process. Someone who is caught with a hand in the till often fights the case afterhand. I mean, we've seen many of these high-profile companies with directors taking the company to court thereafter, and it's rather safer and better to nip things in the bud while it's all internal. So err on the side of caution and look at all possible avenues.
Well, thank you, Albert. I think that's very, very important to remember. I think that when employers deal with this, it's important that you contact SEESA. Let us come out. Let's look at the position of the director, look at his job, look at what he does at the company, and determine whether he's an employee or not, in order to protect you from any further action against you. That is unfortunately then all we have time for today. Thank you.